I was just standing over it, admiring it, not touching it. And then one of Chris's friends said, "Back away from the diamonds." And that's when Chris came in and said, "I'm so sick of all of you people." Took the gun out like this, put it in my face, and said, "Get the F out."
Did you think that he would pull the trigger?
I thought he was going to shoot me.
Well, that woman describing what allegedly happened to her at singer Chris Brown's mansion
some plaintiff, I'll tell you.
last night. She says he pulled a gun on her, as you heard, then she ran out. Now, police arrived on the scene after receiving a 911 call about a woman in trouble. They got there at 3 a.m. Once police got there, they had to wait around for a warrant. During the standoff, Brown brilliantly took to social media to rant about the situation.
When you get the warrant or whatever you need to do, you're going to walk right up in here and you're going to see nothing, you idiots.
He will get arraigned next month. Now, this is hardly the first time he's been in trouble with the law. In 2009, he pled guilty to assault after punching then-girlfriend Rihanna in the face. 2 years later, he stormed off the set of Good Morning America because he didn't want to talk about that situation. He then threw a chair through a dressing door window. Since then, there were several more fights, probation violations, kicked out of rehab, went to prison as a result. He's had more assault charges against him, including by another woman. Okay. To the general public, they say, how many strikes does it take before this guy gets thrown in the clink? Now, my question is, forget about the merits of this case or not. There's 3 strikes in terms of drug offenses in certain states, and there's different things where there's graduated penalties, drunk driving, etc. If there is even commonality here or pattern that shows that he's done violence against women, will that raise the stakes for him in this situation?
So the rule is that prior bad acts won't be admitted as evidence. Sometimes they can bear upon sentencing. I think that should be changed. You know, I think that when there is the same victim with domestic violence, for example, and you want to establish a pattern that they should be allowed in, some jurisdictions like Alaska and California have exceptions for sex assault and domestic violence where there is the same victim, but it's hardly across the board. I mean, it's so specific, and you have to really prove that the probative value of that evidence outweighs the prejudicial value. Because you can't say that just because someone did something once, they did it again.
Mayo, in other states, does that change the fact, or does it have to all happen in California for them to be admissible?
It has to be substantially similar so that it would be a crime in New York State, or a prior bad act does not have to be a crime. But there would be a hearing again, as Amy said, to determine the probative value versus the prejudice. But I'm a firm advocate against having 1, 2, 3 strikes, because sometimes the first incident that you're involved in is of such a magnitude that there should be a significant consequence. Other times you may have 3, 4, 5, you may have addiction, there may be a host of reasons why you get charged. Let me give you a specific example in my head. Kevin Hardy, remember the football player? And we know what happened in North Carolina. We know how it turned out at court, but certainly the charge. If he abuses another woman violently, shouldn't what he did in North Carolina play a role in this? Well, this wouldn't have been his first rodeo in doing something horrible and abusing a woman, theoretically. One thing that we forget is that you're innocent until proven guilty, and quite often we remove that cloak of that presumption of innocence from people. So if he hasn't been convicted, then that shouldn't be considered anymore at all.
But in sentencing, it would be considered.
Well, no, if you're acquitted, you should not have that considered at all.
Oh, no, if you're convicted, in sentencing, that would be considered, but not at trial, because like Mayo said, we want to give people the benefit of the doubt.
It just seems, though, I'm just saying now from the one person who's not an attorney at the table, that when people commit a heinous act and then they look back in their background, they said, my God, the warning signs were all here. Well, look at all the different things this person did. And because they were never formally punished, really, then the message was that somehow tacitly this was okay.
Did you watch the show The Night Of that just ran on HBO?
Everyone's telling me I need to.
Okay.
Yeah.
So they drag in, he's convicted of, on trial for murder. 7 years later, they drag in the fact that he, and it's totally unrealistic, that he threw another kid down the stairs in school 6 years earlier. Got nothing to do with the murder, got nothing to do with the crime on trial, just to show he's a bad actor.
No, but Rich is saying if somebody's a domestic abuser and they do it again, that's the same act.
Look, the trend across the country is to let in domestic violence cases in this prior evidence in. We can debate whether that's good or bad.
Well, we'll follow the case with Mr. Brown here. But guys, Amy, thank you all very much. Appreciate it. We're going to have local headlines straight ahead. Stay with us.